What's up, everybody, and welcome back in. Today, we're going to focus on emergency motions being filed by the lawyers in the YSL case to try and stop this judge from doing further damage. We're going to talk about the procedure, whether they're doing it the right way, whether they have any chance of winning, and how this could affect the already very long and continuously delayed trial. I've got my dad back with me to talk about this trial in this case, as there are all sorts of intricate criminal details and procedures happening that are unusual. These are things that don't normally happen in a trial, but this has already been an unusual trial for a million different reasons. How many defendants, how many charges, how many specific criminal acts, how long the trial is going to go, how the judge has acted, how the lawyers have acted. Everything about this case is unusual. And this is no different, but there are procedures and rules in place to deal with situations like this, where lawyers feel like they have no recourse. They feel like a judge is just railroading them or bulldozing them. And when you ask for a judge to recuse themselves, a lot of times the motion goes to them first and they can just deny it. Well, that situation has happened multiple times here. Dad, explain kind of what this procedure is and what the lawyers are trying to do in this case.
What they've done is they've gone into what we call extraordinary writs. Extraordinary writs are the times when legislatures can't pass laws that deal with all facts. Facts are unique, and sometimes you have to go to the court for some special attention, special redress, because things are so unique that you need some help. So in this case, we've got a writ of mandamus. Most of your listeners probably are familiar with the writ of habeas corpus. That's when you have to bring the body of a person in, and that's the legal definition of it. But what it really means is someone's put in jail and they're not supposed to be in jail, and therefore we have to go to the courts to get him out of jail because his incarceration was unlawful. You have writs of prohibition. Writs of prohibition mean a government agent has done something or is doing something it's not supposed to do, so you want to prohibit them from doing it. So that's a writ of prohibition. A writ of mandamus is when you want a judge or a government official to do something, not to stop doing something, but you want them to do something that they refuse to do. So you want to have the courts force them under a writ of mandamus to do something. In this case, they filed what's called an emergency petition for a writ of mandamus. So not only is it a writ of mandamus, an extraordinary writ, but they're also telling the court that this is an emergency, and therefore they have to take this up right away, or the court's not going to be able to correct the harm that's being done.
And basically, this is a situation where they want to go above the judge's head, but they can't because of, in the last video where we showed Judge Glanville's decision, he took it out of the chance or even the opportunity for the appellate court to hear it based on the fact that he wasn't even going to assume these facts. He said they were legal conclusions and baseless accusations or something like that, and not based in fact. Therefore, he kicks it, it's over, and they move on and they can appeal it later, basically is what he's saying. And what they're doing is responding saying, no, we're going to try to appeal it right now, but it's only if the Georgia Supreme Court wants to hear it, right?
That's right. What the judge said was, I'm not going to certify this. By not certifying the question, it means it can't go to the appellate court. Because remember, there is a court before the Georgia Supreme Court. There is the trial court, an appellate court, and the Georgia Supreme Court. The Georgia Supreme Court took the extraordinary position of taking that contempt issue, where a lawyer is going to be sentenced to jail for 20 days. They took that away from the appellate court. So when they did that, that meant that you could skip the appellate court. And so that's what they've done. They've skipped the appellate court here, saying that the judge won't let us appeal this in the normal way. So we have to go for an extraordinary writ. So that's why we're coming to you, Georgia Supreme Court, to give us some action.
And the percentage of cases that the United States Supreme Court or even state Supreme Courts even accept to look at is a small percentage. Obviously, the United States Supreme Court is a much smaller percentage, but even state Supreme Courts, it's not like they hear every single case people ask, but your chances of getting it heard by the Supreme Court of your state go up exponentially when they've already kind of been looking at your case or recognize your case or realize your case is there, right?
No, you're exactly right. Who would have thought they would have taken the issue of the lawyer being held in contempt? So when that happened, judges watch TV too. They know what's going on, and they know what kind of impression the rest of the world is getting about Georgia and the Georgia court system. So they took that contempt issue with regards to that lawyer, to Mr. Steele. And when they took that, that showed you they're paying attention to this particular case. This has a better than the normal writ chance of being heard by the Supreme Court.
So let's take a look at it. We're not going to read the whole thing. A lot of it is repetitive to what we've already read and some of the other affidavits and motions. But what was that? Oh, I just heard something. Were you doing something on your desk? Sorry,
I was scrolling down.
Okay, it
like
must
you're
be because
doing.
your mic is close there. Okay. I just want to make sure there wasn't something like in my
I was scrolling down the
Okay.
petition like you're doing.
Okay, so this is it. This is the petition for writ of mandamus and stay of proceedings. So we didn't really talk about that. You want to just talk about the stay of proceedings?
Well, they're asking in this writ, and we'll get to it, they're asking for the appellate court, the Georgia Supreme Court, to do several things. One of them is to get rid of the judge so he doesn't hear this this particular issue of recusal. So he has to appoint another judge. The other thing they want is to stop the proceedings until that happens. So that's what they want to stay the proceedings in order for this to be resolved.
And one of the reasons it's an emergency is because they currently have the witness on the stand that they are accusing the judge of potentially being coercive, a partner with the state, forcing the witness to testify. The ultimate issue that the judge is involved in has to do with the witness that's currently on the stand. So they need to stop everything. They need to figure this out with the judge. And if they're wrong, they move on. But if they're right, it could be irreparably harmed in the case if the judge continues to make rulings with this witness as opposed to an impartial judge that they think should step in for Judge Glanville. And I think it's also important. Why don't you explain what's happening in the trial right now as all of this is happening in the background?
Well, because the witness has been, although testifying apparently uncooperative with the what the state thinks he should say, the state is going to play all of his prior recording statements, which I think amounts to about 17 hours. So they're going to play recordings of this guy for 17 hours to show that this guy, what he said on the stand is really not true, but what he said in these recordings is really true. And what they're going through right now, the jury's not even in the courtroom right now. They're going through minute by minute of the recordings. The lawyers are arguing about whether certain phrases should or shouldn't get in or should or shouldn't be played, whether they can object to certain statements as hearsay. So 17 hours worth of recordings is going to amount to probably about 2 weeks of argument.
And while 17 hours sounds like a lot, we've had cases with a lot longer recordings. And usually this stuff happens way before the trial, right? So, and I'm not going to say they knew, but they maybe had an idea that this guy was not going to be a cooperative witness or might be difficult. So this is something they could have and potentially should have handled before the trial even started, don't you think?
Oh, absolutely. And in fact, I've never had a situation where the judge did not order that we resolve our conflicts with regards to these things before we start the trial, because a judge doesn't want to sit there for 17 hours either and take these line by line.
And one of the things we do is we'll just say, we object to page 3, lines 7 through 15 for this reason. And we make all those down and the state will agree with a few. And it comes down to 4 or 5 they don't agree with. And those are the 4 or 5 we take up in front of the judge. Now, I will say with 6 different lawyers and defendants, that makes it more complicated, I guess. But they could just create a shared spreadsheet like we do with exhibit lists. Which ones do you have objections to and why? I mean, there's a better way to do it than like this, it seems to me, especially to delay
and they
the
do have
trial.
transcripts. They have transcripts.
Right.
Because they're using transcripts when they're identifying what statements they don't want to come in. So they had transcripts they could have been working with and redacting so that they could have a transcript of what the jury could hear, as opposed, again, to telling the jury come back in 2 weeks.
Right. It's crazy. It's crazy. And they've had so many delays in this case. All right. We're going to read bits and pieces of this that you highlighted before and just kind of talk through this motion. The petition relates to conduct of the Chief Judge Glanville and not to any rulings or orders of the judge. Now, that's obviously important, especially because the judge cited the reason he thinks they're trying to recuse him is just for adverse rulings.
Right. So, and they're making it specific. We do not care about his orders. We're not complaining about his orders. We're complaining about how he's conducted himself.
And specifically the ex parte, witness intimidation, things like that.
Right.
All right. Citing a lack of evidentiary foundation caused by Glanville's own recalcitrance in refusing to provide a transcript of the secret ex parte proceeding, Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review. Assuming this court would not get the opportunity to review the decisions on the multiple motions to recuse unless or until the underlying case was concluded, Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight for abuse of discretion. That would be on appeal, not on a writ of mandamus.
Right.
Right. That's why they're citing it that way. Glanville's obstruction of defendants' rights to a fair and impartial trial has risen to the level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. Meaning, when they say the Superior Court, they mean Glanville making the decision. They don't think they can do that anymore.
Right. That's
So
a waste of time.
Exactly.
Waste of time.
Which they're right at this point. They've exhausted that option. 3 motions for recusal have been filed and denied. 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than about 1 year. Therefore, any effort for a writ of mandamus in Fulton County that would be heard by Chief Judge Glanville would result in frustration and lack of action. Glanville's court is where writs go to die.
Yeah. And that what it is they filed some others based on some other things like property being returned and, not dealing with this particular issue. Glanville for a year has not ruled on them. So what they're saying is it's a waste of time. It's not going to get resolved timely. And again, the witness is on the stand right now.
Then they talk about the ex parte proceeding. He continued to refuse to give them a certificate of immediate review that would allow the appellate court to review the case. So that's why they're coming to the Supreme Court. Emergency relief is requested because the witness was coerced by Glanville, is presently on the stand, like we said. They're talking about why that needs to happen now because of anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding, but not provided to counsel as required by law, as well as the coercive joint efforts of the bench and the state, meaning the judge and the state attorneys. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Glanville may make during counsel's cross-examination of Copeland, meaning while Copeland's on the stand, you can just imagine it. They're crossing him. They're saying, the judge forced you to testify. He threatened you, didn't he? The state threatened you, and the state's objecting. The judge is going to make the call as to whether or not they can impeach the judge and say the judge put inappropriate pressure. That's obviously not fair and not how it works.
Right. And the jury, again, juries don't know all the background. So they hear this. They think that a judge, again, is the king in that courtroom, and he's supposed to be. And so anything he said is gospel. So when they see that the defense lawyers are arguing with the judge about the judge's conduct, they're not going to go with the defense lawyer. They're going to go with the judge.
The relief sought. As Glanville has found petitioner's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests this court to grant a writ directing Glanville to adhere to Rule 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. So that's the first thing they really want, is to get this in front of an unbiased judge and have them make the decision.
Right.
Petitioner further asked the court that the proceedings in the trial be stayed pending resolution of the motion for recusal. Petitioner further asked this court for a writ ordering Glanville to produce immediately and certainly no later than prior of the start of cross-examination of Copeland an unredacted transcript to defendants of the secret ex parte proceeding held on June 12, 2024. They also asked this court that it enter any further writs or orders it deems appropriate given the actions of Glanville. Anything you want to add there?
No, but again, see what they're asking. They're asking multiple things. They're asking for a copy of the transcript. They're asking for a stay. They're asking for another judge to be appointed to hear the recusal motion. So at least 3 different things.
So then they go through the things that are already in the affidavits that we have heard upon information and belief. It was coercive by Glanville, by the DA. They pressured sworn witness Copeland after he had already been sworn in. They think there's Brady material. They think that the ADA said she would not prosecute Copeland even if he were to lie on the stand. But if he testified that he ended Donovan Thomas Jr.'s life, that he would be prosecuted for that. So basically, they're going to pick and choose what they're going to prosecute him for, and they're telling him before he's on the stand to obviously influence and force his not only his testimony, but his testimony to be what they want it to be.
Well, who wouldn't be influenced if you're testifying by the fact that the prosecutors say, we're not going to, you can lie and we won't prosecute you. But if you say you murdered somebody and we don't want you to say you murdered somebody, well, then we will prosecute you for that. So you can only get away with on the stand what we want you to say. You say something else, we'll prosecute you for it.
And they talk about how when Steele originally brought all this up, Glanville diverted the attention from what actually happened in the ex parte meeting and forced Steele to reveal how he got knowledge of this. Steele refused, and we know he was thrown in jail. What's interesting about some of these hearings is they haven't been transcribed yet, or that transcript's not available, and they actually cite the YouTube site for these judges to go watch it. That's interesting. That's kind of a true crime in media and YouTube edition and newly discovered tool for lawyers where it can be literally immediately available. Back in the day when you used to do a lot of appeals, how hard was it to get transcripts? How long and how expensive is it to get transcripts?
Really, really expensive because you've got to pay a court reporter to work 24 hours in order to do it's like daily transcripts. Sometimes you pay a court reporter to do daily transcript. So the next day you have the transcript from the testimony the day before. It's phenomenally expensive.
And rushed is even more expensive.
Excuse me?
Rushed transcripts are even more expensive because a lot of times it's like, we'll get them after the trial. It still takes forever. But if you want them daily, it's way more expensive.
Right. When you do an emergency writ like this, you've got to give them everything, because if they have to wait, it doesn't become an emergency anymore if they've got to wait 4 weeks or a month to get the transcripts. So that's a way of showing it's an emergency. Plus, I think this is a total of 86 pages. 26 is the actual petition for the writ. The rest of it are attachments, which are the other recusal motions and affidavits, so that the appellate court has everything in their hands. And if they want to see what happened, they can look on that YouTube site, so that they can do an emergency order, at the very least, an emergency order to stay the proceedings until they have time to look at this.
Yeah, I mean, they literally cite the YouTube. They have the YouTube URL right here and a timestamp of 5:45 where you start. It literally looks like my notes when I do recaps of these trials or these hearings. And they're asking the judges, you want to hear it? You want to hear exactly what was said? We're not mincing any words or lawyering or wordsmithing anything. You can go watch and listen to it real time as if you were sitting in that courtroom, which I think is very interesting to see if appellate courts start doing more of that, because I almost feel like you can learn more by watching and listening to it than reading it on paper. Sometimes you lose some in the transcript. I'm sure it'll take forever because, old dogs don't like to learn new tricks, especially lawyers. They hate change. But I do think it's an interesting and different way to do their job that might actually enhance their ability to do their job appropriately.
Yeah, but only really of an emergency nature, because the problem you got is the person who's doing the YouTube copying it, they're not certified and they're not members of the court system. So, you got to be careful that you might have.
What do you mean?
We know that there are people out there that, cut and paste. You got to be careful of that.
Well, no, but I think there are some courts right now where the court is controlling the stream and the audio and the visual.
They're doing that, yeah.
I mean, yeah, and that's about as good as it gets. Like in Brian Koberger's case, straight off a judge's YouTube page is how they're streaming this trial.
Well, that's interesting.
Yeah, and a lot more courts are taking control of the cameras and the microphones in their own courtroom to make sure it's not overly sensationalized, to make sure they're not zooming in on criminal defendants' faces, things like that. So, I mean, that's about as close to certifying it as you can get, but we'll see. Okay, arguments and citations of authority, standard for granting writs of mandamus. Under Georgia Constitution, this court has the powers necessary in aid of its jurisdiction, including the power to issue process in the nature of mandamus and injunction. It allows the parties to seek mandamus to compel a due performance of official duties where a defect of legal justice would ensure from a failure to perform or form improper performance. And there is no other specific legal remedy for the legal rights. Do you think that there is that they have exhausted all other options and they're kind of on their last leg and they have to do this? They don't really have another choice? Or can you think of any other legal options they may have?
No, I think this was the right thing to do. I think that they went there. They really don't have a lot of options. People need to, I guess, kind of remember when like clerks of courts weren't doing certain actions, and they had to go to court to force the clerks to do things, that was a writ of mandamus. You don't see it much with judges. This is a really, really rare case where you ask one set of judges to do a writ of mandamus, asking another judge or forcing another judge to do something. You don't see that very often.
And they go through all the rules they believe he violated. We've talked about a lot of these already. Baptiste supports petitioner's position that Glanville's bias is of such a nature and intensity to prevent the defendant from obtaining a trial influenced by the court's prejudgment. And again, that has to do with Copeland, that has to do with his actions towards the DA. And you've seen Steele and Glanville specifically, but also other defense attorneys get into it with Glanville. He accused them of being unprepared. The bias is starting to show. Now, without the ex parte Copeland situation, it's probably going to be tough for the defense to really get anything done. Adding that, I think, does change the scenario a little bit in the totality of the circumstances. Not only did Glanville fail to notify defense counsel about the ex parte proceeding as required by Rule 2.9, he made every effort to conceal the proceeding. And then a lot of this, Glanville, Attorney Steele, there was no disclosure of the ex parte proceeding, which is now subject to the show cause order. Indeed, quite the opposite takes place. Judge Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might already have disclosed. So they attach the show cause order where he's basically like, everybody that's at that hearing, at that ex parte meeting, show up, tell me you didn't tell anybody or I'll throw you in jail, is basically what he did. So he's trying to keep them secret. And then this is in conclusion. Here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing and who also has actively attempted to conceal the proceeding, in my opinion, to a reasonable degree of legal certainty. This conduct legitimately calls into question the judge's impartiality and, assuming it to be true, would require recusal. Again, I reach this conclusion based on Judge Glanville's actions, not any ruling that he has made in the course of this trial. Petitioner requests this court direct Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed by this court to assign the motion for recusal to an unbiased judge for hearing on the merits. Petitioner is further requesting a writ ordering Glanville to immediately produce an unredacted transcript to defendants of the secret ex parte proceeding. Petitioner further requests that proceedings in the trial be stayed pending resolution of the motion for recusal. Petitioner also requests that this court enter any further writs or orders it deems appropriate given Glanville's action. So they're not even asking for them to really recuse or kick Glanville off altogether. It's just let somebody else, let an unbiased judge hear the recusal hearing, determine whether Glanville should be recused, and then go from there. Whatever that judge's decision is, the defendants have to live with it. They want the transcript. And then a third thing I don't know that we mentioned, they want to stay the proceedings, obviously. Then a fourth thing I should say that we haven't really gotten into would be other writs the Supreme Court deems appropriate. What other writs could that be?
Well, the Supreme Court has the right to fashion any kind of remedy that they want. So, basically what they're saying is, look, Supreme Court, we're not going to tie your hands. You think of something else, you go ahead and do it because, you're the Supreme Court.
Theoretically, they could sanction Glanville. They could kick him off the bench. They could do all sorts of stuff, right?
Right. They could send it to the grievance. There's a Judicial Qualifications Commission. They could send it to a grievance to the Judicial Qualification Commission. They could do all sorts of things.
Yeah. And then they're just saying like, hey, we think this is really bad, but this is all we're asking for. If you guys think it should be even worse, have at it, basically. Right?
Right.
All right. And then let's just scroll through real quick and see some of the stuff they attached. Some of the motions to recuse him, they attached. A lot of these we've read. Information from the affidavits. The specific affidavits themselves are in here. Additionally, we have the order to show cause somewhere. Order on motion to recuse. So this is his order. And then we have more affidavits just to show you how much they attached to this motion. In addition, they don't even have the hearing, the motion to quash the show cause order. Do you want to talk about that at all? Hold on a second. What were you saying?
Page 3. Actually, it's page 46 of 83 of this.
Go ahead. Just talk about it. I don't know.
Right.
I got to find it.
All right. Here is something interesting. Remember before we said they didn't specifically say things happen in the judge's presence. In this affidavit, upon information belief on the morning in Chief Judge Granville's chambers, in response to Copeland's statement. So these conversations about we're not going to prosecute you actually did happen in the judge's chambers. So the judge knew about it and he heard it.
Anything on the quash? We didn't talk about that very much.
No, the only interesting thing was
I can't really hear you while you're scrolling. Sorry, it's so loud.
okay.
It's just
Give
because
me
it's
a
like
second.
bumping on your thing. So I'll just keep going, and then you get to where you need to get, and then you can go. So there's also this order to show cause that we talked about, that we read through again, that they have a major problem with, and obviously it'll be interesting to hear how the Supreme Court feels about that. And then again, more affidavits about the wrongdoing during the ex parte proceeding. So a lot of supporting documentation, plus the YouTube link. Everything the Georgia Supreme Court could possibly want to review on this case, they have, in addition to the trial in its entirety that has been streamed. And nothing prevents them, Dad, correct, from going and looking at even other stuff that wasn't attached to this if the lawyers are asking them to potentially file other writs. Now, for what these lawyers are asking, it's usually limited to what they put in the four corners of the document, which would include that YouTube link and not the entire trial. But if they see a major problem that in the interest of justice, they need to step in and do something, they are legally allowed to do that.
Yes, they can. Now, in the response to the order to show cause, what I wanted to point out, because I missed it when we were last time when the judge was talking, I didn't hear this, but the judge specifically stated the word she has in what the judge said about how did you learn about this. The only people in there were, and the judge went through it when he was talking to Mr. Steele. And then he says, and then because she has a client that she was supposed to represent, they picked up on that.
Oh yeah, everybody did. Everybody knew
and realized that. Yeah, he's specifically talking about Copeland's lawyer. He's already decided Copeland's lawyer.
Everybody from the jump picked up exactly who the judge thought it was.
Yeah.
The female lawyer, Bumpus, I believe is her name, that was representing Copeland. And obviously, and just if you look at what the defense's motion and what the defense is saying, they're saying basically everybody else in the room was in there to coerce and force Copeland to testify the way the state wanted him to testify. You got bailiffs, you've got investigators of the DA's office, you've got multiple DAs, and you've got the judge that they're saying worked in conjunction with the DA to make sure this happened. And that's where the problem lies. And that's really what the Georgia Supreme Court is going to have to look at. I mean, the judge's actions in this case are above and beyond bad. So what do you expect to happen here?
I don't think it's going to be very long. I think the Georgia Supreme Court is going to issue an order on this. If I'm prejudiced, but if I was them, I'd go ahead and grant the stay and look into this a little more to find out whether this judge should be recused or another judge appointed to hear the recusal. This is not something you can just brush off. This really is outrageous, and everybody sees it.
So what judge would it be? What judge would it be if they said we're going to find an unbiased judge? Is it just another judge in that jurisdiction? Is it an appellate judge? Who would it be?
It'd be a judge of the same rank in that jurisdiction.
So that's interesting, right? Because they could be friends. He's the chief judge. So even if they rule that, which I hope they do, I don't know. I don't have enough experience with these to know what these judges are going to do. I would hope they're going to at least get an unbiased judge. And frankly, they can continue to do this. I guess they actually can't, right? If there's a motion for recusal, you've got to kind of pause everything this judge is making decisions on with regards to Copeland. So they're going to have to stay the trial. I hope they put an unbiased judge out there to listen to this, to hear these issues and see if the judge crossed the line, abused his discretion or not. And if he didn't, then we move on because the judge has looked at it and they can appeal it later. But if he did, we should get this corrected now and not waste all this time and money and resources going forward on this incredibly laborious trial just to have to do it all over again.
Right. It'll be a judge within his jurisdiction, though.
That's interesting.
That's the way it goes. Yeah.
Yeah. That's why this stuff is hard. That's why this stuff is hard, because do you want to be the judge that, says the chief judge has to recuse himself from this after he has obviously fought it tooth and nail? Hopefully somebody's got the backbone to do that, so that'll be big. Anything else with this that we need to touch on?
Nope. I think that's the most exciting thing that's happened now, because what's going on in court is really boring right now.
Yeah. Yeah, we'll keep paying attention. You guys send a bunch of DMs about this, so anytime you have a question on this case, shoot us a DM. We're still gonna keep an eye on it. We'll follow up on it. We'll answer your questions. Make sure you guys hit that like button on this video. Make sure you subscribe to our page. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.